Today we have the pleasure to meet you here in Vietnam and in IBID office. So we would like to discuss a little bit about the new law. So the new RIA law have like a lot of new things available that led to a lot of change in the law. So Nataliya, can you share with us what is new about the new law and how it affects to the investor?
Well, this is a really, really good question because some really good things and good developments came out of this new law that went into effect in May of 2022. One of them, and this is probably one of the most major changes and positive changes that happened, is the ability to file the 526 e-petition at the same time as the adjustment of status or the green card application from inside the US. And the legal term for it is concurrently, so at the same time. So when you have the investor in the US in lawful temporary status, right? It has to be that somebody was admitted to the US in lawful temporary visa status, and they can then file concurrently their 526E and adjustment of status green card application. But that's not all. The concurrent filing ability extends not just to people filing the 526 petitions under the new law. It also extends to people whose 526 petitions are pending under the old EB-5 law as well. And so if you have someone who filed their petition some time ago, and we all know we have investors like that in Vietnam because unfortunately the immigration service, like we've said, is taking a really long time with processing, unfortunately. But those people in the US who are investors with pending 526s and they're in lawful temporary status can file their adjustment of status green card application while and wait for the 526 petition to be adjudicated while in the US. The benefits of being able to file in this way are really, really, really great. For instance, after some time, based on processing times, people whose adjustment of status is pending receive authorization to work in the US and authorization to travel internationally while they await the adjudication and approval of first their EB-5 petition and then their adjustment of status. So gone are the days when people who were even in the US were forced to wait for the approval of the 526 to be able to file for adjustment of status. This is something that can now go in before the approval is ever issued, allowing people for that flexibility to remain in the US and ultimately be able to work and travel.
Yeah. So that's really, really good for the investor who still have opportunity to work, to travel, while their EB-5 case still pending.
Yes.
Yeah.
So another aspect of the new law is something that is maybe not as at the first thought of it as exciting as the concurrent filing, but also very important and very good, is the sustainment period of the investment funds has been detached or removed from the immigration process. And this is something that is also extremely, extremely important. So the sustainment period is a period of time for which the investment of the EB-5 investors has to remain at risk, and conceivably after the sustainment period, subject to the terms of each individual project that the investor contracted with for their EB-5 process. And so now the sustainment period is 2 years from the time that the investment funds drop from the new commercial enterprise into the project. And that starts the 2-year clock, but also in order for that to set the clocks to satisfactorily end, the jobs, of course, have to be created. So no one wants their money back before all the jobs are created, because if they get their money back before, they're not going to qualify for 8 to 9 approval, because they will have no relationships to the creation of the jobs at that point. But the extreme benefit of this detaching of the sustainment period of time from the immigration process was that it resulted, and we're seeing out in the market, shorter term loans that are being, obviously driven by this new change in the law, and that in turn is beneficial for the investors. Now, I will caution, that if someone is, talking to you about an EB-5 project that's guaranteeing, 2 years, I would be very careful about that, because just practically speaking, a project is going to need reasonable time to get on their feet, to finish building, to create the jobs, to get enough value in the project to perhaps sell or refinance, because where else is the money going to come from? So we can't, yes, the loan terms are getting shorter, and that's great for investors. And now you don't have to count, the time, the 2 years between, it's not tied to your conditional residence status. But we want to just remind everyone to be careful when they are choosing the right project, and not be tempted by, promises that potentially may not be realistic, in light of this. I also wanted to briefly talk about another really exciting change that came about at the time the new law was enacted, and this is the visa set-asides. So within the approximately 10,000 immigrant visas that are allotted for EB-5 program, for everyone in the EB-5 program, there were created set-asides for specific projects, and those would be projects in rural areas, projects in areas of high unemployment, or government infrastructure projects. And those set-asides, what a set-aside means is literally that, We're taking some of the visas, a certain percentage of each of those types of projects that I just said, and we're allocating them directly, specifically to those projects. And what that results in, is for people who go into those projects, a greater chance of availability of the visa, and almost like a, being, guided in a separate lane from everyone else, I guess, so to speak. And really the government has stayed true to their word in giving preference to those types of filings. And so the rural filings tend to be adjudicated within 6 months or so, which is, we haven't seen those types of speeds, with the immigration service since I want to say like 2013, right? So 10 years later. The high unemployment projects, I think, you know, the immigration service doesn't post processing times for those, but are probably, you know, between somewhere approximately at 24 months, which is still very good. So for those potential investors considering an EB-5 investment, I would keep those things in mind, because that could get you the ability to get your green card a lot sooner.
Yeah. So with the new law, allow the investor first concurrent filing, it means that the investor have opportunity to work, to travel while their I-56 is still pending. Secondly, the investment times is by new law is 2 years. However, like Nataliya just mentioned, the investor must be very cautious about the time, because it's like talking about the financial benefits for the project. The project it takes a lot of time for to do the documentation, to finish the project,
to build, to become economically sound.
Yeah,
these are all things that are important ultimately for the success of the entire green card process, creation of the jobs, but also for their ability to pay you back.
Yeah, that's right. So the investor have to be very carefully about the two-year refund term, and another benefits for by the new laws is the visa set aside. If the investor invested in rural projects or high unemployment projects, they may be able to get the green card sooner.
Yep. Yeah. That's right.
So thank you very much for your information. Yeah. So I would like to discuss a little bit about what happened recently at the consulate office in Ho Chi Minh City. So we already discussed that USCIS may request like additional document for the start of the fund or the pass of the fund when they adjudicating I-526 or I-829. And at the consular officer, was my experience in the past, I never experienced that they issued 221G to ask the investor to provide this documentation. However, recently, U.S. consular here in Ho Chi Minh City required this document. So it's quite a little bit confused to me and to investor.
It can be concerning.
Yeah.
Yes. So I would say, so this is you know, we were talking about the State Department immigrant visa process, and in the past, as you know, Jenny, as you said, we've been in this market for many years, and we have dealt with the immigrant visa process through the U.S. consulate here. Well, it's that way, I think, in Ho Chi Minh City. For quite some time, right? And so throughout periods of time, they have gone in certain cases and requested through the 221G process additional source of funds information. But that was usually very rare, and it was in very specific cases where they would have a specific concern. For example, if somebody went in for their interview and had no idea, you know, where their money came from, right, for the EB-5 investment, and couldn't answer any questions about it. Not a good idea. Everyone, of course, should be very well prepared with their case going in for their immigrant visa interview. Or if the source of the funds, for instance, was a loan that they took out, but then it turns out that 2 days after they took it out, they repaid the loan, right? So now that makes the consular officer wonder why that happened and why take out the loan in the first place. What is the issue with the source of those funds? So, you know, the 221G process specifically for source of funds was very limited to those specific types of cases. But over time, and most recently, the requests, the number of requests, and the nature of these requests has become much more extensive. Mm-hmm. And so a couple of things that we're seeing is that a lot of requests regarding source of funds are made by consular officers at the time of the immigrant visa process. And also what we are seeing is extensive contact by phone from the consulate to the applicants asking for additional things, okay? And so when that happens, of course, it can be a little bit confusing, it could be stressful, right? And so if for those that, you know, that come to have to deal with something like that, I would give the following advice. First of all, when you go in to the interview, you have to be prepared. You have to have reviewed closely the 5 to 6 petition cover letter. You have to know intimately and in detail the source of funds. You have to really even down to bringing with you a copy of the petition, not to give, but to you're holding it, and if questions come up, knowing where the exhibits are and just taking them out and handing them over to the officer. This is my social insurance documents. This is the property valuation, right, that resulted in it. This is my tax return. This is my employment record. Definitely cannot be going in and not be able to answer extensive questions to the officer, you know, at the time of your interview. If you cannot answer questions at the time of your interview, that is most definitely going to really increase the chances of getting a 221G request for additional evidence. And I would also say that it's really important to keep your agent and your attorney in the loop of what happens. A lot of the times, because everyone, by the time they go to the consulate, they're tired. They've been waiting a long time. They just want it to be over. They just want to get the visa and get on with it and come to the US. It's just been one thing after the other, you know, and it's stressful. And so when they get these requests, they think to themselves, oh, I'll just deal with that. I don't want to spend the time to go back and tell my agent or the lawyer or whatever. It's too complicated. It's going to prolong this, and I just want to get this done. I just want to get this done. And so it happens that by the time that we hear about something like this having been going on, it's already been going on for some time. And that isn't great because we want to be strategizing together in these types of situations. So you would go to your agent, you would tell them, listen, I went and I tried to answer all these questions, but they told me they didn't have any questions for me. And then later they called me and they said that they want these things. Now, if you're leaving the interview and they're giving you notice of, say, administrative processing with no additional requests or something, and you're about to walk out, I would just very nicely, it's important to be very, very nice, I would just say, officer, thank you so much, but just a quick question. I want to make sure we're, you know, documenting all the requests here. Can you just, if you have anything that you need from me, can you write it here on this 221G? And that lets them know that you know that they have to document in writing their request. Or if they call you the following week and they say, oh, you know, I just thought of these things that you can get me. Absolutely, I'm happy to get it for you. But I have a lawyer, and my lawyer is going to be helping me get it together. So can you please send me by email the 221G updated with the requests? Because I have to give this to my lawyer so we can work together on this, okay? This is very important because now you're obviously not arguing, because we don't ever want to argue, and you're being very polite and very nice, but you're letting them know that you know that these things have to be in writing. And we need to keep them in writing because that is the procedure that's required. They can't just keep calling and asking for new things because that's not proper procedure, and we want to steer them as much as we can. So those would be the three, you know, sort of main pieces of advice that I have on this.
Yeah. So I think like since you haven't like well prepared before going to the interview is really important.
Yes.
So that's help the investor build the confidence.
Yes.
In answer the question.
Yes.
No wells about their petition to be able to answer the questions of the consular officer smoothly.
Yes.
Confidently.
Yes.
And in detail.
Yes. And we always send through a copy of the petition, right?
Yeah.
So really it's important to review it and be familiar with it. And then even to go so far as to maybe, I know it's a lot because when we filed, it's this giant stack of paper. But you would really just bring it and know where everything is. Even put like your little tabs into it to help yourself. And that way, if you're in the interview and the officer, they should have these in the file. But if they can't find it or they're not sure what anything means, and you are confident because you've prepared and you've reviewed and you know where, you say, oh, you know, I happen to have this here with me. Look, here's my documents. Here's my this. Here's my that. Do you want it? Because, you know, I have it readily available. Not to come and just give it to them. To keep it just in case. And if it comes up, you're being helpful and you're just kind of giving piece here, thing there.
Yeah. So as IBID, so like we usually bring out all the I-526 packet and let the investor study for like what is in the pocket. Let them have time at least, like usually we give the packet to them at least 1 week before the interview day for them to relocate what the paper does. To study, to know like what we wrap up in the pocket. And also as IBID, we provide at least 2 interview training. It's just not, I don't call it training, but like help them to remember what happened in the case.
Absolutely. It's been years.
It's
hard to remember. And you know, when you're talking about source of funds, I mean, we're lawyers, right? You're an agent who deals in this space. We know that all of these processes are very specific in how to talk about them, but investors don't. They just can, you know, oh, I think my money came from, they don't think it's a problem. They don't, you know, they have a million things going on in their lives. We're the ones that put it in the format for immigration, so that's why it's good to review it.
I just go with them to go over all the information that's already revised in the I-526 pocket to help them to remember.
Perfect. That's
so they will like build their confidence on the on the interview. And I think your advice regarding the asking the consular officers if about the like additional document, if they ask that put in the 2221G.
If they're not giving you anything, just say, you know, don't bring it up in the middle of the interview. Like if you give me a 221G, you have to write it down, right? You don't even know if you're getting it. But if they're giving you a 221G notice with nothing on it, right, then just say, oh, officer, I just want to make sure if there's anything that you think that you need for the administrative processing process, please could you note it down on this document here, and I will get it to you as quickly as possible, and my lawyer will help.
Yeah, I think that's a very great advice, because like help you as a lawyer, as me at the service agents, and also help the investor to understand like what the consular officer really want to know about the case, better than just know nothing, just wait for the administrative
but also, you know, verbalize it to them in the right way, in a way that like, we're here to give you the support that you need, right? I want to help you adjudicate my case. What can we do for you, right? Instead of maybe, you know, getting frustrated with them or not saying anything at all, right? And not speaking up. It's good to, in the right time, right, to be able to say something about, you know, what can I get you? What I want to help you. What can I get for you that you think will help you? And preparing, I think, is, you know, I think that's great that IBID does this. It's extremely important to go over what's in the 526 filing, but also to practice answering those questions, right? Because it's hard to be in that setting, right? You're in front of a U.S. government agent, and they have a lot of power in that moment over your life. And you want to feel comfortable, as comfortable as possible anyway, answering questions in the right way, and making sure you get out what you need to get out during the short window of time that you have with them.
Thank you so much for your sharing today. I think that's really benefit for IBID and also for the investor to understand about the new law, and also to have the best preparations for the interview. Thank you very much for joining us today.
Well, thank you for inviting me. It was such a pleasure, and it's such a pleasure working with IBID. We love hearing from the team, and we love being able to help the investors. So if there are any questions, please feel free to reach out. We're happy to help.
Thank you very much.